thank you again. Attendance has been tremendous at this event, and we really appreciate it. And really hope you can stick around for networking, because we'd love to mingle and expand your networks. And today at this panel, right now we're going to talk about legal matters, advisors, how to structure your company, how to structure your boards, and really piggyback on a lot of what the panel was talking about earlier this afternoon, in terms of to quote Clifford Holcamp, no wonky terms. So maybe our a panel of attorneys can talk a little bit more depth about what are some of the standard terms and what types of things should you avoid, because when you do have an angel investor interested in investing in your company, it is hard to turn that money down. But we're here today just to provide you some great advice. I'm sure it's going to be a little bit like drinking from a fire hose. So please be patient with us, because this is a really complicated topic that we're going to try to cover in short order. So without further ado, I'd like to introduce the panelists and our moderator. So Harry Rader with BioSTL Fundamentals. I'll just go in order here. Catherine Love with Brian Cave. Marquita Barbieri with Carmody McDonald. Andrew Special with Pulcinelli. And Gita Rao-Sant with Washington University School of Law. So thank you very much. Harry, you can take it away.
Okay, Michelle, thanks very much. So I like to get a little bit of a sense of who's out there first. So hands in the air, please. How many of you are involved in startup companies right now? Okay, that looks like a third. How many are thinking about it? And how many have decided not going there? Nobody. All right, so everybody's open-minded. That's good.
At least on the legal topic.
Yeah. So, and you came to a legal conference, so good. So that's a wise thing to do. Welcome. As you heard, we're going to be the Legal Matters panel. I am not a lawyer, but I'm sitting up here with your new best friends, because you're going to find it surprising to hear a business person say that, you know, lawyers are actually a good thing. But when you're starting a company, you really do want to start off right from the start. I'm going to come back with a story in just a minute, just an example of that. But anyway, so Catherine is going to cover business formation. Marquita's going to cover the talent pool and how you establish a legal relationship with your board, advisors, and ultimately employees. Andrew's going to talk about, you know, the whole valuation exercise in a company and how that's done and when and why. And then Gita is going to talk about how to get in touch with and work with lawyers. So those are the topics that we're going to cover here today. We're going to invite you all to raise questions at any time during the panel, and I'm going to act as sort of a timekeeper and try to keep us on track and on time. So if I break in and ask you to take the conversation, if it's getting a little too detailed, I might ask you to take it outside of the room, at which point, you know, please just honor our wishes there, because we got a lot to cover. So thank you very much for that. So I'm Harry Rader. I'm a serial entrepreneur. I've started 10 life science companies with more or less success. You know, about 5 of those are ultimately going to exit. 3 are either in the money or have exited already. And positive exits, by the way. And I'm now a full-time entrepreneurial coach. I see several of my mentees in the room, so welcome to you. So BioSTL Fundamentals is a program that offers coaching and resources to life science companies. It's open to anybody who wants to create a startup company in the life sciences in St. Louis and who has either a patent or a patent filing, or a idea that they think is patentable. So it's, you know, pretty broadly open, but you do have to have a patent filed or patentable technology. And you know, so I mentioned that we provide coaching. We also provide resources. So most of the resources have to be earned by coming in and listening to the coach. That's me, right? But there are some resources that are available free of charge. We provide training for SBIR and STTR funding, so non-dilutive funding, which we can get into in the hallway if you want. And we also have something called the BioSTL Life Science Entrepreneurs Roadmap. And so this is a downloadable PDF. It's on the BioSTL website, and you just have to give us your email address and other information, and it's a 65-page PDF that's organized as a FAQ, or frequently asked questions. So the first 2.5 pages are questions and you click on them, and it'll take you to the point in the document where that topic is covered. It'll also take you to outside resources, by the way, that can further your business education. And a lot of what we talk about here today is covered in a summary fashion, and even in some cases in some detail in the Entrepreneur's Roadmap. So by all means, those of you that are getting involved in this and haven't seen it, download it. It's free. We think it's fun. Seems to be popular with people. Okay, so I thought that I would just pick a war story from my time in one of my startup companies. And this is a company that actually I took out of the University of Illinois at Urbana-Champaign. It ultimately had a terrific ending to the story because we were successful in selling the company to Abbott. But a mistake was made right in the very, very beginning that damn near ruined the company and prevented us from selling it. And the mistake was because of some well-meaning thoughts on the part of the founders. There were 3 people involved. 2 were inventors of the technology. And then a 3rd person, they were told by the tech transfer office that they needed a business person to come into the company. And so they said, hey, yeah, what about that guy that spent the summer at Sigma as a bench scientist? He worked in a business, he's a business person. And so they then decided he'll be a founder of the company with us. And they then divided up the equity, the ownership of the company, and they gave everybody an equal share. So those of you who know business are smiling because you know what the likely outcome was. It ended up in a huge tangle of threatened lawsuits and unhappy people, and it was a real mess to unravel. But other people are wondering, hey, well, what's wrong with that? 3 people? Divide 100 by 3, you get 33 1/3. Why isn't that fair? Well, the answer is it really has to do with what people are bringing to the company. And these other people had actually invented the technology, and the other person never actually really did accomplish something. So there's actually legal ways to think about that all in advance and make sure you're doing the right things. And that's sort of the kind of topic we're going to be covering here today. So that's my little story. So with that, I'm going to turn it over to the experts, the true experts here. And they're going to tell you about their various topics as we discussed. Break in with questions anytime. Thanks. Take it away, Catherine.
All right, thank you. Well, speaking of free resources, before I start answering, I will make a plug for Brian Cave also has a free resource, which I think is very helpful for entrepreneurs. It's a micro site and blog called startupbriancave.com, and that's BRYANCAVE.com. So check it out. There's a lot of good information there, and you can also subscribe so you get updates when we post pieces. Okay, so I've been practicing for about more than 20 years in our corporate and transactional practice, and a lot of the clients I work with are entrepreneurial, and I do everything from figuring out what kind of entity they should be on up to exit transactions. But what I'm going to talk today about, and feel free to ask questions as we go along, is that very first decision of what kind of entity should I be? And maybe even the question that comes before that is, why do I even need to have an entity? My plumber operates just fine, and I write him a check as Joe Plumber. But in starting any kind of business venture, you do want to have an entity, and the reason is having an entity gives you liability protection. So if something goes wrong, whether with the product you invented, or say you have an employee that gets injured, any kind of risk, if you're operating in a corporation or an LLC, some sort of entity, and you're doing it right, then the worst you could do is lose your investment. You won't lose your house, your life savings, whatever. So any lawyer you talk to will say, yes, you need an entity to form your company. And if it's just owned by one person, it is really very, very simple. Often you'll have multiple founders, it gets a little more complex. They're going to tell you about that in a minute. But don't be scared of the time and cost of getting set up, because it's definitely worth it. So there's 2 main types of entities that I think most entrepreneurs end up in, either a LLC, a limited liability company, or a C Corp. So C Corps have been around forever. That's the original type of entity. And the advantages of a C Corp is they're very tried and true. And you can get sort of very standard articles, bylaws, also even investment documents. There's real norms that have developed about what an investor document would look like. Also, employee stock options, all those, there's sort of some standard approaches. So your transactional costs of getting into a C Corp, I think, tend to be much less expensive than getting into an LLC. There is, however, a downside. And what we would call that is double taxation, because the corporation, in the IRS's view, is a person, meaning that if the company makes money, the company pays tax on the earnings. And then if the company were to make a dividend to the shareholders, then the shareholders also pay tax on the dividends. So there are ways to structure around that kind of thing, but that sort of double taxation thought is the reason why people like LLCs. And so what an LLC is it's got the same liability protection advantages of a corporation, but it has partnership taxation or flow-through taxation, meaning that the LLC, and Marie, you can correct me if I'm saying any of this wrong, but the LLC itself doesn't pay taxes. It flows through to the owner's tax returns. So if you have profits or losses, it just goes right through to the owners. And again, if you have one owner, it's pretty darn simple. It goes right on your 1040. If there are multiple owners, you get a K1, a little more complex, but at least it's not double tax. So now you're probably all thinking, oh, of course I want to be an LLC. That's so much better. But there are downsides to the LLC. Number one is that if you're going to go for venture capital investment, there's a lot of VC investors that don't sort of, for various reasons, want the hassle of having an investment in an entity with that flow-through taxation. Secondly, the great thing about LLCs and the bad thing about it is they're so flexible. You can really write your own deal. Instead of having sort of cookie cutter bylaws and shareholders agreements like corporations, you can write your own deal. So that is a real benefit, and it also means it's a complication because you have to spend time with your lawyer and your founders thinking about, well, what is our deal? What do we want to do on exit? How do we want to handle taxes? How do we want to handle operations? So the downside, I guess, is it can be more expensive transactionally. The Harry's rule of thumb, which I like, is if you're gonna make revenue, if your entity is projected to make money before you need to take in outside investment, then an LLC probably makes sense. If it's the reverse, that you're gonna be just in startup mode and then need to raise money, then probably for various reasons a corporation is gonna make more sense. And my one final tidbit, which it sounds like is probably what you heard earlier today, is keep it simple, keep it standard. There's lots of important things for an entrepreneur about being creative, but don't try to be creative with your legal documents in your business deal, because it's gonna, if not come back to haunt you, at least cost you more money.
All right, Catherine, that's excellent. So now, who has questions for Catherine? Because this is complicated stuff. I know you don't all know it. Good.
So the S Corp option
Yeah.
also allows flow through.
Yeah, so I'm glad you mentioned that. So an S Corp is, it's like a C corporation, only you file an election that says we want the flow through taxation. So it's got similar tax treatment to the LLC. And I think it's sort of fallen out of favor because it's very constraining. The rule, you have to make sure you follow the rules sort of perfectly, or you can end up blowing your election and then owing a lot of tax. And the main constraints I think people see are you can only have a limited number of investors and you can only have one class of stock. So you could have common stock. So if you're going to do any kind of bring in angels or venture capital investors, you can't give them a preferred stock like they would typically expect. Also, other corporations can't invest in an S Corp. So, they make sense in a circumstance where you're going to be the sole owner and run your company forever. They can make a lot of sense in that circumstance. there's a whole, I won't even get into self-employment tax. They can make a lot of sense, but this is where it makes a lot of sense to sit down with an accountant and a lawyer and talk and say, here's how I see, here's my idea and what I want to do, and here's how I think it's going to play out.
Can I do a follow-up?
Uh-huh.
If you pick one and you make a mistake, or just circumstances change, how easy is it to reclassify yourself as a different one?
It depends. How's that for a lawyer answer? You can make some switches easily without a tax cost and other ones not. You can go from an LLC to a C Corp tax-free, which is a good thing. A lot of companies do that.
Actually, I think Catherine said something really important in there, and I want to make sure everybody got it. She said several things that were important. One in particular, which is, she said to talk it over with your accountant and your lawyers. You know, we've given you a rough rule of thumb, but every situation is different. And that's why you want to get professional advice. Okay? Other questions? Yes, over here.
My business is, I've started as an organization, a nonprofit, but I'm wanting to just go to LLC. It's in the service industry, and so I'm thinking, and if you can't answer this too broad for here, then just tell me I'm fine. I'm looking at, am I right to think I need to just dissolve that one or phase it out and then restart that it as an LLC? I mean, I'm changing the name too because it'll make more sense now. I have a different direction.
So that's another one where there is some complexity, but yes, I would say, you know, nonprofits have very strict rules because the way they're set up for the government, the theory is we've given you this tax advantage and the assets of the entity, you know, need to be protected for a nonprofit purpose. So I think you're better off addressing that entity if you decide to go out of business, donate the assets, whatever, and start fresh. But we can talk more later.
And then the last one, sorry. I know some people put names, like they'll say an LLC or INC. I mean, is it important to do that? Should you do that when you come up with a name for your company?
Yeah, so your entity, whatever you decide to be, LLC, corporation, you should use, at least in your principal legal documents, the type of entity in your name. And Inc. and corporation mean the same thing.
Okay, so we're just going to have to move on to our next topic. They're excellent questions. Thank you very much. So Marquita, tell us how we document the talent pool.
Sure thing. So Catherine's teed up the types of entities that you can have. And with each of those entities, Catherine did mention that there's certain documents that go with each type of entity. So for the corporation, as Catherine mentioned, you kind of do have a little bit more of a standard set of documents. They are the bylaws and various investor documents that, you know, hopefully reflect your reality, but are a little bit typical for investors to see. Another document that's key in the corporation setting is a shareholder agreement. This is a document that you would have to work on as a founder with your other founders. This document would deal with how you're actually transferring ownership of shares in the event of people's death, disability, divorce, or if you just want out, or if you just don't like each other anymore. So in Harry's example that we've kind of woven through most of our answers today, if you've got a situation where you no longer want to be owners with somebody, hopefully the shareholders agreement will help address that issue. The goal is to talk about it when you all like each other, not when you're all really, really angry at each other, or you're very uncomfortable with each other. And, you know, you kind of have to have your best laugh about it. I encourage my clients to just, you know, kill each other off, you know, talk about your spouses. You know, you all wanted to work together, not necessarily with the lovely wife or the lovely husband. I'm sure they're charming people, but you didn't want to go into business with them. So you have to deal with those things head on at the beginning, or else you're going to have problems because life changes. People do get divorced, people do get injured, people do pass away. So we encourage you to actually invest in that discussion early on, and that will be a legal expense to you, but I promise you will be less expensive to deal with that document now versus when everybody's upset with each other and you have lawsuits threatened when you all own 33. That document can also help deal with some tiebreaker issues, talking about who's voting for what. And those are very helpful conversations to have up front so that people have a sense of exactly who's doing what. The flip side agreement for a limited liability company, an LLC, is called an operating agreement or an LLC agreement. You'll hear both of those words. Unlike the corporation, as Catherine was mentioning, the documentation is pretty easy to set up the entity, and there's not the bylaws and other types of documents, and the big kahuna document is the operating agreement. That document, again, deals with management issues. Unlike you can have officers in an LLC, but you'll have managers, either one manager or a board of managers. And again, you want to deal with death, disability, divorce, buying and selling the interest, the membership interest in those companies in the same way that you would talk about buying and selling the shares of stock in a corporation. Again, make it reflect reality. Talk about who's managing what. What's really helpful about the operating agreement structure is that it's a forum to really lay out the manager's authority inside that document. You can do a similar exercise for the shareholders agreement and inside resolutions for both types of entities. So you can keep expanding upon the authority of who's exactly doing what inside that document. In Harry's example with everyone owning a third, it doesn't mean that we don't do it. It can still be your business decision that that's what you all decided. We typically encourage against it, or we discourage it, because we do want you to value, whose idea it was and what that really means and whatever the other contributions might be. And you want to be able to have a tiebreaker situation in any event. So those are things to think about. So that's kind of ownership and where you need to deal with those issues and transfer issues inside those big documents for both entities. Appointing your board members and how you can compensate them and how you deal with those issues is also inside the operating agreement and the shareholder agreement or in those separate resolutions. And both entities, corporations and LLCs, have that resolution structure. So at any time, you can kind of sit down as owners and make a resolution that says, we hereby appoint Bob to go open a bank account, or whatever the task might be. Inside a corporation, your shareholders, the owners, they appoint the board members, your board of directors. Those board of director members then appoint your officers, president, vice president, secretary, treasurer, what have you. That's how that flows, and that's all done by resolution, and you work with your attorneys to make that happen. Again, you'd be sort of outlining what those roles mean. The bylaws that Catherine mentioned, those typically outline in very dry terms the role of the president, the role of the vice president, how those resignations can happen, how reappointments can happen. So that's where that happens for a shareholder agreement. Guess where it goes for the operating, or for the LLC? Just gave away the answer. It goes in the operating agreement. So again, you'll be dealing with those appointments of who the manager is. Typically, we don't see as many officer appointments inside an LLC, but you can do it there too. Same story. Talk about what a president means. You can call yourselves whatever you want. Hail King of the Jungle, whatever. We don't typically see that, but hey, Build-A-Bear's got Chief Bear Officer, you can do it. All of that would happen inside the operating agreement for the limited liability company, okay? Questions about those structures and where those placements go inside those two entities? Because I'm going to move on to the next group of people, and I'm talking a lot.
I have a question about if you do split a company 50-50, do you have some strategies for tie breaking?
Yeah, absolutely. We work through a lot of different tie-breaking strategies. They can be from appointing a third party that's outside the company, like an accountant. Your lawyer will likely decline because they represent the company themselves, and that's going to create a conflict. Your accountant might also decline. But if the two of you could agree on a neutral third party to help make that tiebreaker, that's helpful. Sometimes we also see a little bit of, in 1 year, this member gets 2 votes, and in the next year, the next member gets 2 votes. So they could alternate sort of which year or what series of years, a person has veto power or that second vote power. There's a lot of creative solutions to do it, and we really do encourage you to think of one of those and work with your attorney to be creative in that area, because it will trigger at some point that you'll want it. Or we really do just say go 5149. Come on. Any other questions about that? Yeah.
You keep saying you're a lawyer. And when you're starting up a company, you don't always have a lawyer. So I guess I hear you saying you need to get one.
I think you should. At least you're going to have
You're hearing us
unanimous
loud and
vote
clear.
up here for that.
I have some hints for you.
Well, and this is where we really do want you to take advantage of the resources that are out there, but also call us. Most attorneys are happy to talk to you up front, and my rule of thumb is please call me before you do it. We promise that we work with startup and emerging businesses. I know it's scary to call a lawyer, and you think instantly you're going to drop at least $5,000. Maybe you will, but it's going to be a new bathroom, no. But, you have to look at it a little bit like that this is an investment. It's going to be a startup cost, and it necessarily doesn't have to be that much. We do have budgets that let us set up those documents for you in a really efficient way. We've done a lot of them. You're going to get this advice very quickly from people, but we also need to hear what your reality is. No matter what, we're going to suggest to you advice and counseling based on what you teach us about your business. So it's not that we know everything, we learn from you about your business, and that helps us give you the best business strategy and the best legal strategy. So when you hire a business lawyer like one of us up here, you're actually getting two for the price of one. You're getting a business consultant plus a lawyer. None of us do litigation work. We're not there to fight. We want to get a deal done, and we want to set your business up so it can go make money. We all sleep at night because we like making money in America. So that's what this panel is.
Think about when you go to, as individuals, you go to a doctor for preventative care, right? You want to make sure you stay healthy for the rest of your life, or you have all your teeth or whatever. It's the same thing with law. When I teach at WashU, and when we talk about what we do for our clients in the clinic is we're practicing preventative law. We're practicing law so there is not something horrible happening later. So we're going to set up the foundation in a way. You may cost you $5,000 or whatever up front, but later on it's going to save you $150,000. So it's preventative care for your organization.
Just to piggyback on what both Catherine and Harry said earlier, one of the things you want to do when you're initially starting a company is keep things as simple as possible. And I guarantee you the easiest way to keep things simple is to get an experienced group of professional advisors around you. You don't want to be breaking ground with the structure of your organization because that will put off investors. Now, your technology, everything that goes into your organization, great. Break all the ground you want, compete against Apple, Microsoft, everybody. But don't be a maverick when it comes to setting up your own entity.
So we're going to have to cut off the questions on this topic there. Obviously, this is a very important topic. And again, we're just sort of laying the groundwork. By all means, ask people questions during the break. So Andrew's going to talk to us about a very important topic having to do with valuations of companies.
Once again, my name's Andrew Special. I'm an attorney at the Posanelli Law Firm. I've been practicing for about 10 years or so, the last 5 years at Posanelli. I do about 75–80% of my work in the startup space, representing both initial companies, called issuers, as well as investors. So I've got a 50-50 split between which side of the coin I'm going to be on in any given transaction. Harry graciously enough offered me the valuation topic, which is an interesting one for a legal panel because it's probably the one that all four of us are the least qualified to discuss. Let's start with a simple example. We've got a one-member company, one shareholder company, and the intent is going to be that company is not going to have to go outside and raise any additional capital. It's going to either be self-funded through contributions that the founder makes, or it's going to generate revenue on a really quick basis that will allow the company to continue. Who cares at the outset what this company is valued? Anybody? No. There's absolutely nobody who cares, except the founder, should he decide to sell a company at some point. But that's its own level of negotiation. So, but as soon as you introduce a second founder to the mix, now all of a sudden that valuation issue, what do we have and what is it worth, becomes paramount. It shouldn't. If you have a company of 2, 3, 10, 20 that is just starting out, any ideas what that company, just off the top of your head, would be worth? Let's say we've got a company of 10 people. Throw out numbers. Anybody say something? 5 million? Great. Anybody else want to throw out a number?
10,000.
10,000. I like 10,000 better than 5 million.
How about minus 500,000?
There you go.
There's the reality
Yeah.
check.
Your company is worth absolutely nothing. It is absolutely nothing the day you start it. That enables you, if you can wrap your head around that concept, which is a very difficult thing to do. Obviously, we all own somewhere inside our minds the next multiple trillion dollar company. But that's just not reality. If you recognize that this entity today is worth nothing, that makes a lot of the discussions that you're going to have with your founders a lot easier to have. You know, if we're dividing up nothing, it doesn't matter if we divide it up evenly. It doesn't matter if we divide it up 99%, 1%. 99% of nothing is still nothing. It's worth the exact same amount. Now, all the other issues that we talked about still come into play, because the goal is that valuation will continue to grow over time, and you're going to be eventually you'll start talking about some legitimate dollar amounts. But you're not doing that right now. So don't get so tied up in valuation at the early stage that you lose sight of what it's going to take to get this company to succeed at the next level. And I would probably extend that argument to even early stage financings. I don't know who's familiar with the general timeline for investments, but a lot of times we've got founders who come together to join a company. We've got a group of angel investors, generally high net worth individuals, that somehow or another have relationships either with the founders or are introduced by the founders, who make certain early stage investments. Even at that stage, when we have outside money coming in, you're probably not going to have a knockdown, drag out discussion about valuation that means anything for the business prospects going forward. Yes, you're going to have discussions about what percent of the company the investors will own for their amount of investment, so that is inherently a valuation discussion. But later investors aren't going to think anything about the valuation that you've agreed to for those early stage investors. Everybody knows how the game is played. Companies need to get money through the door so they can expand their operations, grow their technology, and turn it into something that everybody's happy to have. A lot of times that early stage investment, if it doesn't come in the form of equity, it's going to come in the form of convertible notes. That's probably the most frequent valuation mechanism or financing mechanism early on, and valuation at that point really means nothing. When you have a convertible note, basically what you are selling, if you're the company, is you're selling a right to convert a certain amount of debt into equity on terms that are negotiated in the future. And the biggest advantage of those convertible note offerings is you are eliminating that sometimes difficult to have valuation discussion right now. Now at some point, after you've gone through some early stage financings, gone through potentially one or multiple convertible note rounds, you will run into an investor who presents you with a term sheet that has that dreaded line in it, pre-money valuation, X dollars. That's where, in earnest, the valuation discussions really start to take off. Because at that point, it is a straight negotiation. What is the value of the technology that the company has at that point? And there's likely that the valuation is still probably very close to zero, especially if you've taken on a series of convertible debt. Now, nobody who represents the company is going to say, all right, I'll give you X dollars equity at a pre-money valuation of zero. We always come up with some arbitrary number, and that's really what negotiations are for early stage companies. I would venture to say that companies probably would have as much success, walking up 15 feet from a dartboard, throwing a dart and seeing on what 7 or 8 numbers it landed on, as far as an actual valuation of what the company is worth at that point. But everybody's focused on it. And really, my focus in negotiations is not so much whatever that value number is. It's what additional rights are companies giving away to get that value? How much voting control are they ceding, not just in terms of shares, but in terms of special approval rights that they may be granted to future equity holders? That's really where I start to play with the valuation number. Not so much trying to get investors to go from a $6 million pre-money to an $8 million pre-money. But let's try to make some other terms that are more comfortable, more company favorable, if we can do that.
I'd like to break in with just a little quip that will illustrate the point. So who here has heard of the golden rule? So in business, the golden rule is he who has the gold makes the rules, all right? And what does that really mean? It means that this valuation of the company is going to be worth what people who are willing to invest in the company say it's worth. And that is the fact of the matter, whether we like it or not. Now, you can take their money or not. If you decide not to take the money, then there isn't a deal. But when Andrew says this is established by negotiation, that's basically it. The company's worth what people outside of the company say it's worth. In other words, people that are willing to make an investment. So do you want to open it up for questions, sir, Andrew?
Sure.
How does the valuation conversation change once the company has debt, say bank debt? And whether or not one or more of the founders have personal guarantees on that?
That's a good question. In the pure startup scene, frankly, I'm not involved in a lot of companies that have bank debt just because of the nature of the assets that would require to be pledged for that. Now, if there is obviously the existence of senior debt, potentially has a hampering effect on the valuation, at least from the investor's standpoint, because the debt holders will clearly be paid off first. So potentially a dampening effect, I think. But at the same time, there are companies who are clearly successful that have both equity financings going on and the existence of prior debt. But it always factors in the discussion, and investors always want to get as much information as possible about that pre-existing debt.
Another quick question before we turn it over to Keith.
Right over here. Yes.
What role, if any, in your opinion, would you want to have to place the safe agreements versus shares versus the notes in this valuation and such? Do you think, some, I'm sure it's relatively new. I think there's still a lot I haven't learned about that.
Yeah, I started seeing safe instruments probably about a year and a half or 2 years ago. Unless I'm completely wrong about the information I've seen about them, they started on the West Coast, maybe on the East Coast as well. And as everything, it takes a while for things to migrate to the
Everybody knows
flyover
what a
country.
safe agreement is, right? Just to,
No, I
okay.
think you need to elaborate.
Okay. A safe
Sorry,
agreement.
I didn't mean to interrupt
No,
you, but I'm
no,
like,
that's
I have a
a
feeling.
very good question. So I talked about the convertible note structure, which I think most people are familiar with. So you loan the company money, and then at some future point, that the interest and principal of that convertible note will convert into equity securities of the company. A safe, a simple agreement for future equity is designed to accomplish the same thing. You have an upfront payment that will later be converted into equity of the company upon certain future milestones. The one component of a safe is, for balance sheet purposes, it does not appear as a debt of the company. it's kind of floating somewhere. You know, clearly the company gets the asset in terms of the cash, and there's a corresponding obligation to issue equity in the future. As far as where that's captured, that's something for Marie to answer.
And Marie,
As good.
it floats right onto the balance sheet, doesn't it,
Yeah.
Marie?
Yeah. But yeah. So I am more comfortable, and I think most issuers are more comfortable with the concept of that. I said issuers, I meant investors, are more comfortable with the concept of convertible debt. However, we are starting to see more safes be in existence, and I think there's somewhat of an approaching level of comfort with it.
Don't they also not have a maturity date?
So it depends on the terms of the safe, but yeah, some do not have a maturity date. So it's an extraordinarily open-ended obligation to convert into
So
equity.
so again, if you have the privilege to raise money that way, discuss it with your advisors.
Yeah, I would add though that I hope they become more normal and established in this market, because I think they are on the West Coast and in Boulder.
There's a great imbalance in the investor versus investee or startup power, where if you can convince your investor that you might take their money, but you don't need it, your valuation is very different than if they know you need it. And it has nothing to do with the difference in your company. So it's really a power game of leverage, and I think the SAFE agreement is a slightly more balanced issue.
And I think, and to my theory of the lower we can keep the transactional costs, this is one of the ways that I think a lot of law firms and the venture community, particularly on the West Coast, has tried to, let's standardize it and take transactions. So I hope they become a
I'm
popular,
seeing
but I would
them
agree.
more and more
Yeah.
in the Midwest as well, both Chicago and here. And the rationale is, if you have a convertible note, okay, you have debt on the books, but if the company tanks as a startup, the person will never get paid back. So the people who are comfortable with a SAFE agreement, they're taking the exact same risk. You just have a piece of paper in a convertible note that says, I have an IOU, but you can never pay it. So it's 0 on 0 on 0, and the SAFE is, okay, here, I'm throwing my dollars at the wind. If you make it, give me some equity. If you don't, well, I guess I'm not getting
I'm going to use my moderator's discretion and cut this topic off by all means.
Great topic.
It's a great topic, and it's new, it's really interesting. Let's take it outside. So we have a little bit of time for Geetha to talk, because we've talked many times today about how important it is to have a lawyer. So how do you find one? How do you start that relationship off on a good foot?
So I'm Geetha Sant. I teach entrepreneurship law at Washington University Law School, and I run the Entrepreneurship Clinic, which is why I believe I'm invited today. So now that we've scared your pants off about why you need legal services and what horrible things can happen without them, so how many of you have $100,000 in your legal budget? Anybody? 50,000? 10? Maybe 5? Okay. Oh, good for you. Good for you. Congratulations. So one of the things that I think is really cool about our community in St. Louis and our ecosystem, the entrepreneurial ecosystem here, is the tremendous amount of resources. So without the $5,000 budget, even with the $5,000 budget, you want to make sure you use that $5,000 as wisely as possible, my guess is. Your burn rate on that $5,000, if you go to, with all due respect, my brethren at the bar, and I practiced law for 22 years before I came to WashU to teach, is, if you're doing it for articles of incorporation and setup and articles of organization, you're going to go through that $5,000 for some very basic work, right? So the other way to look at it is find resources to help you do that kind of work so you can save your $5,000, $10,000, $100,000 to pay these hot guns over here their billable rates and at the law firms that have the resources that you need to go beyond that. So a couple examples I wanted to touch on. My clinic. So WashU has a clinic. Sorry, I just touched the microphone. Washington University Law School has a free clinic for all nonprofits and startups coming out of the community with less than about $200,000 in annual revenue. And my guess, based on some of the questions you've asked, many of you may qualify for that. Legal services, everything from entity formation to kind of get you to kind of seed, not quite early stage, and then we ship you off to a law firm. By then, hopefully, you'll have some capital to spend on that. St. Louis University Law School has a similar program. Their focus is slightly different, more on kind of community development. UMSL has a similar program, and Webster University has a similar program. So we are lucky to be in a community with robust university support and help in this area. Community development agencies. For example, Legal Aid here in St. Louis of Eastern Missouri has a CED program, has a community development program that helps entrepreneurs and startups that have some sort of community development or economic development focus find legal services for them as also. Law firms, tap these law firms. All three of these law firms that are up here, I've known well, I've known many for many years. They all have pro bono hours. The partners have requirements to have pro bono hours. Brian Kay, for example, has that the pro bono site and the blog that you can get information and maybe some templates and documents, things like that. Polzanelli, all of these guys up here have that. So tap those. And I want to point to Harry, there are so many organizations and incubators and accelerators, mentor services, things like that, that also come with some legal services. And the one thing I want to tell all of you guys, and maybe it's because I'm a little, sighted, narrow-minded because of the WashU, but there are so many competitions and programs that you all should be applying to. Find them, apply to them. Almost all of them come with X dollars worth of free legal services from your law firm, for example, your law firm and your law firm. And certainly from BioSTL Fundamentals, they have some services in terms of patentability opinions they can provide for you. So tap those resources before you hit the 5,000 or the 10,000 mark. Save that money to pay these guys. And it's not, maybe it's a little bit of self-promotion for our clinic, but it's not just us. There's so many other support systems in town that can help you. So one of the things I want you to think about is why you need a lawyer. Go back to that. And I called it preventive law a few minutes ago, but think about it as when I teach my students in the entrepreneurship clinic, I think about it as preventive law, but I also think about foundations to success. I kind of almost want to change my clinic from Entrepreneur's Law Clinic to Foundation for Success Clinic. When you think about a foundation, you think about the four walls, the concrete, the rebar. It's no fun. You guys don't want to focus on the law. You guys just want to get to the good stuff, the mission, the widget, the success stories that I want to sell to Abbott, I want to sell to Microsoft stories. But you've got to lay that foundation now. And that foundation, why you need a lawyer, and as Marquita was saying, it's just not lawyers. There's a difference between lawyers and counselors at law. You've seen both, right? You see attorney at law or counselor at law. I think we tend to be counselors, especially in this space with entrepreneurs. We want to think about it as counseling. So when you think about the four walls of a foundation, think about the first wall that's kind of the legal issues, entity selection that Catherine talked about, things like that. The second wall is financial. I think about you've got to have your financial structure in order. But guess what? You need a lawyer for that too in terms of figuring out where the money's coming from, how it's coming from, where it's going out. Personnel, we talked about shareholders, but think about vendors and suppliers. What's going to make your entity sustainable? What kind of contracts are you going to have? You need lawyers for that also. And then finally, I think of it as kind of the operational wall. Do you need a trademark? Do you need a patent? Are you going to be able to get a patent? Do you need a printer or a copier? Are you going to lease it? I don't care. Or do you need a property lease? All of those things, if you think of the four walls that are the foundation to success for your organization, lawyers have their hand in each. So when you finally graduate with a $5,000 budget or $10,000 budget, you have some decisions to make. Are you going with a big firm or a small firm? There's differences. A big firm has big money. Their rates tend to be a little bit higher, but they also have the breadth of information that you might need. They have the depth and the breadth that you might need. A small firm, you may be a bigger fish in a smaller pond, but they may not have the tax expert there. They may not have the other experts that you need. So it really depends on your style and what you need. I would say when you interview firms, talk to the partner in charge, compare and contrast, figure out what their expertise is. The big question to ask is, how many other clients like me have you worked on? What is special about my case that you think is going to be either a hurdle or a home run? Think about those things. What is your fee structure? Don't be afraid to ask about that. It seems icky, but we're all used to you. When I was in practice, we're all used to you guys asking. Ask if there's an arrangement for a flat fee. Ask if there's an arrangement for a pro bono rate. Or if you're a startup, is there a startup rate? Maybe it's a fixed cost. Maybe it's a fixed fee. So ask about the fee structure. Ask about billing. Ask for itemized bills. I will tell you, having been as a consumer of legal services and a provider of legal services, itemized bills make a big difference. You get to know, what you're looking for at that point. You know what you're paying for. Are there 16 people on the case, or is there just one person on the case? So make sure you kind of look at the lawyer as your counselor, but as somebody who is your supporter and as your partner in your endeavor.
Geetha, thanks. That's really a great summary. And so we are over time, and we were asked to wrap it up at 10 minutes still. So I guess that's really all the time we have for it. Thank you very much to our panel, and thank you all for your questions and your attention.